earlier said, we would open the floor to questions and all of that. So, next slide. So before we dive in, yeah, before we dive in, I just want to give a quick 30-second introduction as to what our day-to-day looks like over at Advisory. So at Advisory Legal, or let me just speak for myself. I spend most of my time on corporate and venture capital advisory, essentially helping founders to raise, negotiate term sheets, structure their company properly, and all of this is done from day one. And we also handle founder separations, M&As, which is honestly where you learn most about what goes wrong when the paperwork isn't put in place, from the beginning, right? A good chunk of our work and my work is cross-border structuring for companies across Nigeria and also advice on fintech regulation. So I spend a lot of time with the CBN, SEC, Nigeria data protection rules, and all of that. Just simply put, and this is what I used to say, and I still say it in as a joke, but not really a joke. I'm the lawyer that founders call when the handshake deal has already gone wrong. And so my goal for today is to ensure that that's not you, essentially. So I think next slide. I think the screen is a bit okay, great. So this is what we'll be spending our 30 minutes or less on. We'll first of all start with what due diligence actually is and then what it isn't. And then we'll walk through the due diligence universe, what I call the due diligence universe, which is really just a map of everything that investors will look at, right? And from there, we'll go through the red flags that kills deals. Then we'll look at the cross-border curveballs, right? That catch African founders often raising money off guard. And then we'll see your investor ready toolkit. What does it look like? What does your data room timeline? What does it look like? And finally, we'll just look at some easy, quick wins that you can start with this week. And then, yeah, then just be over to you to just ask your questions. Next slide. Okay, so this is often well, I call it the mindset behind due diligence, and this is what people would think about due diligence, that oh, they're going to face a firing squad. To them, it's like an interrogation room. They're innocent, but they're sitting across the table, and then so some of them go in a bit scared, a bit worried, like they treat it like an interrogation. But let's have a reframe of what due diligence actually is. Due diligence is not an interrogation. That's the first thing you must know, right? It is the moment that your business actually has to prove on paper what you have been saying out loud. So you imagine all the times that you probably pitched to probably an uncle or someone who is looking to invest a good amount of money in your company, and you've said a lot of things, right? You've watched a lot of videos, you've positioned yourself, you woke up in the morning, you looked at yourself in the mirror, you said, oh, this is how you're going to say it with all the T's intact. But essentially what due diligence is what you said, now prove it on paper, right? Now I just want you to think about it for a second, right? Every confident sentence that has come up in your pitch deck or in your elevator pitch, right? Every claim about your IP, your team, your traction, your ownership structure, due diligence is just simply the process of checking whether the paper backs up the story. I don't know if that makes sense. I hear something I see again and again in practice. The most common reason a signed term sheet falls apart isn't valuation. It's not because of valuation. It's not even because of the business model. It's what the due diligence would often uncover, right? And that's usually the moment you're sitting on at the edge of the seat and you're just waiting to hear back. But if you've done your job and you've had your lawyer, a good lawyer who puts you through the whole process and ensure that your data room was tight, you might not be as jittery as if you had not even done anything in the first place, right? So essentially, as we go further, I just want to ask everyone, and you can just feel free to drop this in the chat. Who here has a cap table, right? That you'll be a little nervous to show a stranger. And this stranger could be someone who just says, you know what, I have 2 million I'm not using. Let me just invest. But can I see some documentation? Can I see your cap table? Can I see your data room? Do you have something like that? Do you have that in place, or do you have one that, or you have one, but you might be a bit jittery to share that with a stranger? You can just drop that in chat. And honestly, there's no judgment here. This is exact reason why we're here. So don't feel uncomfortable to drop that in the chat. It's just so that we can at least gauge where our audience is at this time. Next slide, I think. So, what really is due diligence? What is it? I would think about it and this is just me, and I think this should also be you. I think about it through two lenses, and then I ask the same questions, but I carry out different stakes, right? Because if I'm looking at it through the legal lens, there is what I would ask. But if, for example, the investor is my client, there is what I would ask, right? And so I look at it through two different lenses, and I think that's what every intelligent founder should do, really, so that you are best prepared on both fronts. And I would say, so just on the screen, you can see what the questions I've asked for due diligence is: the company who it says it is, right? This is where we go behind the scenes and we check, the registration and corporation documents in whatever country that um they claim to have been registered in. I would, check if it actually owns what it claims that it owns, right? I'll check if there have been liabilities, and this is where all your previous contracts come in, your old contracts come in. I will look at it. Okay, are there liabilities here? Where the past decisions, were they properly documented? Did they go through board resolutions, proper board resolutions? There's some sort of, not sort of, there are decisions that should be made in a company through its board. It's not a unilateral decision. You just wake up in the morning and say, the Lord just spoke to me that I'm going to change all the objects of the company, or I'm going to change. Yeah, that doesn't happen, and that should not happen, right? You say, oh, I just decided to know. There should be a proper there should be proper documentation, and the proper documentation in this regard, and for that context, would be board resolutions, right? What did the board say? Did the board come together to sign off on this? Who signed off on this? What majority of the board signed up on this? All of those informations, those details, they are so important when it comes to due diligence. And you would think it's not important until it becomes important. It is very important. Now, on the investor lens, I would ask questions like almost the same thing essentially, but just with money attached. Because yeah, you're thinking, okay, this is this person's coming in with some money. So you have to ask questions like, oh, can I trust this cap table with my money? Right? What could blow up after I wire funds? What are the things that if I don't fix it now, or if I don't ask questions now, it could blow up after I've wired some money? Will my shareholder rights actually hold up? Do I have any rights in the first place? Just looking at the term sheet, what are my rights in this company? Is the founder building a company, or is it just a hobby? You will know the difference between a company and a hobby from the legal lens. What structure have they put in place? Again, like I said, if you're the kind of person you're the kind of founder that just says, oh, I just decided to, or I spoke to my best friend and she just said, oh, I should just change the company name. I should just change. Yes, conversations like that they're not conversations that a founder, an investor wants to hear, right? We want to see, or the investor wants to see that this person is actually building a company and not a side quest, not a hobby. Do you understand? And here's the useful part. If you prepare for the legal lens, you automatically pass the investor lens. And essentially, it's the same homework that's just created by two, different people. But what I like to even say is, if you prepare for with the legal lens in mind, and you also have the investor lens in view, That is, you are putting yourself in a position to answer the questions that your investor may or may not ask. You are in a better position. Yeah, next slide. All right. So the due diligence universe essentially is just us getting specific as to, when an investor, for example, sits or an investor's lawyer, let me put it that way, sits down to do due diligence on your company. They are really looking across six categories, right? Think of this as, like I said, it's a universe. You cannot do one without the other, right? Every one of them is linked to the other. And I'll tell you how, just as I continue. Now, the first is corporate and cap table. The corporate and cap table, essentially the cap table, just like I've already asked us if we have one. And if we have one, is it one that we are shy to, or we'll be a little bit scared or jittery to share with anyone? It's essentially a table that just shows us who owns what and can they prove it, right? It's very simple. It's that straightforward. Who owns what and can they prove ownership? That's all. Now, the second is the IP and technology. Now, this one essentially just tells us, if just looking at the or sitting in the office of the investor's lawyer, I'm asking questions like, does the company actually own its core assets, right? Your code, your brand, your product, right? Many times, and I've seen this happen over and over again over the course of my career, is that by the time we get to this point, you find that, and then just a bit of research at the trademark registry, or just something as simple as the trademark registry, very, very simple um, um historical research to find out who owns that trademark across the 45 classes, and then you find that the company, doesn't own that trademark. They don't even know, or they will say something like, "Oh, we have been thinking about doing it, but we've not gotten to do it yet." Yes, so that's a red flag immediately. Because again, branding is important. I'm sure that conversation will come up later on during the course of the conference. But branding is so key. I've had situations, or I've seen situations where a company who they had gone so far, they had started, their product has gone into the market, they'd gone far, and then by the time the investor was going to tell them, okay, you know what, you guys go and register your trademark and then come back to me with your acceptance letter, then we can talk again. By the time they were going to go and register in that particular class, the name was not available. And interestingly, the name was taking maybe 2 months before they went into market. So essentially, the moment they came up with the name, if they had registered it, they would have had access to the name, which was very sad. And then I mean, at that point, we could not really do anything because the name was exactly identical. Like the Lord spoke to both of them at the same time. It was like, oh, and the person was really like, I really thought about that name. I said, well, it's good for you to have thought about it, but better for you to have done the needful, which is to trademark it, right? Even if you felt like, oh, maybe I might not use it again, you are safer, you're better off trademarking that name to avoid rebranding, because what happened to them was that they now had to bear the cost of rebranding the entire product, changing their theme, changing their products, going back to the drawing board, and then also still trademarking the new name, which was a bit of a cost to them. Yeah, so essentially of course, this is something that is very critical at the due diligence stage, so that you're not wasting your money as an investor. You're not putting in money in a company that doesn't even own its name. The third will be the contract and commercial. Here is just where we ask questions like, are the deals that actually make you money documented anywhere? Okay, where are the documents? And then we look through those documents. Or are they just sitting in someone's WhatsApp chats? That would be dangerous, right? So just to look at the data room, again, the data room would have a section or a folder where where all your key contracts with vendors, where all your key contracts with suppliers, manufacturers, depending on your type of business, API integration documents are documented. So those are the things that we look through, and those are the things that are expected to be in your due diligence, in your data room, essentially. The fourth will be your people and employment. This one is pretty straightforward. This is just, are your founders, you have a founder, do you guys have an agreement? I see it more often than not. I would even say 70% of the time that people just get into agreement. So, oh, we've discussed it, but we've not really you see that we've not really can cost you a lot. Oh, we've had that discussion, but we've not really gotten to the point where we put it that we've not really decided, yes, that we've not really is a problem. It's a problem because by the time there's a problem, then there will be a problem because there's nothing on paper, there's nothing to say, oh, who owns what, who brought in what, and then everybody, it's now a case of he said, she said, we said, they said. And you want to avoid that from the beginning. The number, I always say that the number one thing that breaks down a that breaks down a solid business idea, a solid product, a solid partnership is is the people, right? Where there's a lack of consensus, where there's just you fail to document whatever it is that you did, in the genesis stage. You fail to put down, properly documents what has been done and who gets what at what time. It becomes a big problem, and people just, it's as is the nature and what I've seen just from experience, and I'm sure some stories are coming to mind, is that people just want to kind of like bring down what they are not a part of, if for whatever reason they're exiled from the company, in whatever way. So sometimes some of the good companies with great products, they fail because people have people have just failed to do some basic things like document their agreements, document what should happen in event of a dispute, simple things like that. The fifth would be regulatory and compliance. Questions like, are you registered with the CAC? Who are your sector regulators? Are you compliant with them? Okay, if you're not compliant with them, where are you currently with them? Are you sitting on a fine? Are you sitting on a fine that is about to blow up in your face? Things like that, questions like that. Your data protection, in today's, day and age, especially backdating from 2023 when the NDPA came into force. The Nigerian Data Protection Commission has been very strict and very, on the nose with their ensuring that the provisions of the act, are not flouted. And, it's not just fines that you stand to well, penalties that you stand to pay. You also have, uh, I think, I'm trying to remember now. Yes, there's a prison time. There's imprisonment of up to 1 year, 2 years, just for failure to comply with the Nigerian Data Protection Act. Yeah. So essentially, every single deal that I have touched on, in the past. Okay, we're also looking at your financials. Do the numbers match? Again, this is also very important because if you've been telling investors a story, you're telling them, oh, this is what we have, this is what we have, this is what we have, and your financials are not matching, you know, it's a different story. It's not, it's in fact, if from the get-go you don't already have your financials in place, something that just looking at it, your maybe by your CFO or your, finance team, just looking at it, the investor should be able to tell the trajectory of your business. If you've been bootstrapping, they should be able to tell, okay, they've put in this amount so far, and this is the result of that amount that they've put in. So if I put in this amount, this is, I can expect to see this kind of trajectory. They should be able to see that when they see your financial. So essentially, all the deals I've touched on, you know, would usually just touch on all of these six tenets in this due diligence universe, as I call it, right? And if you miss one, that's usually where the deal could slow down. So if you miss your cap table, that's a problem. If you miss your IP, that's a problem. If you don't have your people and employment in place, that's a problem. So essentially, if you miss one, that's where the deal would slow down. Next slide, please. Okay, we're looking at the red flags that kill the deals, right? In my experience, they either kill the deal or they stall them, one of the two, right? And oftentimes, in due diligence, in investor, anything that has to do with money in this life moves fast, right? So the moment you slow down, there's something that will happen to that money. Either that will no longer be available, or you know, it's not freely flowing to you anymore just because of that hold up, right? Now, number one is the cap table nobody can fully explain. Now, if you can't tell me off the top of your head who owns what percentage of your company and why, that is a red flag already. Number two, and I'm just going to skim through this. If the IP, again, because I've already discussed it in the previous slide, if the IP was never formally assigned to the company, this is a big issue, right? If a developer or a co-founder or a contractor built your core product and never assigned that IP, maybe via an IP assignment or a shareholder or a software development agreement that has a robust IP assignment clause, then the company may not actually own what they are trying to sell. Now, I have seen this in actual practice, and it was a mess. It was a huge mess because by the time the person who developed the core product said, you know what, don't bother paying me. I'll keep the product and I'll make use of it. There was no, I'm not sure how the founder had come to us at the point where he had already engaged this person, paid the person to build their core product, and all of the source codes and everything was with this developer. And then the developer ended up saying, you know what, uh, I'm not going to I don't want to collect payment anymore. Just take your money back. I'm going to keep the product. And it was just very interesting how that turned out, but it could have been avoided, without us having to drag the matter maybe to court or anything. It could have been avoided with a very simple agreement. So yes, this is a very, very major red flag. Number three would be the handshake agreement where you have no paper trail at all, right? Just say things like, oh, but we agreed verbally. Oh, we're very, very close. We're very close. We're best friends. In fact, he's my father's brother's uncle. Yeah. If you don't have it written down, it is not a defense in due diligence, right? Number four, I would say one founder, no backup, and key person risk. What I mean by this, and what I mean by key is what I call a key person risk, is where if the whole company lives on one person's head, the investors start to get nervous, which is why they will always ask you what's your team made of, who are your team members, who are those on your board, who are your advisors, because I was about to say something, but let me just hold off on it. So it shouldn't live on one person. It should not be the whole company should not be one person. You understand? There are people who, when they build, because they are so emotional about building, they're building and like, it's my idea, it's my, yes, that's great. But it's also not, it's not a marriage. You understand? You are building and you have to build with other people in mind. In this one, people should help you. It's not to put asunder, but you should have other people involved, right? In the building, in advisory, on your board, do you understand? So that you don't appear like a risk to the investor. Number five would be the sole director decision with a hidden conflict. For example, a director who approves a transaction that they personally benefit from without disclosing it. Again, the karma frowns against this. This is a corporate governance nightmare, should not be happening. And yeah, those are major red flags as well. I think I already touched on that in the previous slide. Number six will be regulatory silence. This is where you essentially it's operating without the registration of your maybe without the required registration, for example, or licenses that your sector would typically require. And the thing is that any of this can slow down a deal. Two or three together combined. If you are looking at the six red flags, and already you are a very crimson red, you are bloody red, you are two shades in, three shades in, four shades in, well, you know that you're already looking at you know a deal that could walk away. You already know that you're not prepared to go get to the due diligence stage or to even have a conversation with any investor. Slide 8, please. So this is just like I just want you to picture this in your mind, right? Now, this is just a story, a composite story. You can call it a blend of patterns, right? Of everything that we've already seen across deals, right? And it's not to any specific client. Now, for example, there's startup A who walks into due diligence with a clean current cap table, right? His cap table is not dated 2024 in 2026. I say, oh, I forgot to upload. I forgot. We have a very recent one, but we have not uploaded it, but we'll still upload it. Yeah, things like that should not even come out of your mouth at the point of conversing with an investor, right? This person, his IP, the startup's IP is properly assigned to the company, all their contracts are filed and properly indexed. They have a good data room, within 48 hours of being asked, their term sheet, you know, their term sheet signing will just go straight to, 6 weeks or less. Then there's startup B, right? That's what they have is their verbal agreements. They have no documentation, right? It's the same market. In fact, startup B might even arguably be a stronger, stronger product, right? But they have no documentation. Their agreements are verbal, right? The as IP assignment clause is missing, for the MVP, their co-founder is saying, oh, I thought I had 40%. It's 40%, you told me. So, oh, no, it's 30%. That's a problem, and things like that. The deal will eventually store for 4 months. And when it finally closes, it's very possible that the valuation can be renegotiated downward, and in this case, right, we're looking at two startups who have the same product, same market, but very different outcomes, simply because, you know, of how they prepared or how they got ready, right? Next slide, please, so I can start to round up. Okay, now cross-border curveballs. Now, for the Lagos founder who may be looking to raise money globally, and I suspect that that may be some or most of you, there is a whole additional layer. So imagine everything we've already discussed. Now add all of this to it, right? Many of you are working with or will work with holdcos, what are holdco holding companies, and opcos as operating companies structures, right? So think of it this way: think of it as your Delaware holdco sitting on top of a say Nigerian or Ghanaian or Tanzanian opco, right? The moment you have more than one jurisdiction involved, right? You're you have it's no longer one compliance clock that you need to look at. You're now looking at two companies, two jurisdictions, rather. That's what I meant to say. You're not looking at two jurisdictions. You're not looking at just Nigeria or just Delaware. You're looking at Nigeria and Delaware or Ghana and Delaware, depending on where you have your operating company structures and your holding company structures, right? Then you also have the foreign exchange, right? Every cross-border, payment that you make or receive will come with exchange control considerations, and so you need to get that right, right? There's also the tax residency and transfer price, and these are all the things that you need to know about if you're cross-border. That is, you are like I gave an illustration. You have a Delaware entity and a Nigerian maybe operating entity, right? You have to look at the tax residency, transfer pricing, for example. Investors lawyers will ask you where your where your company is actually managed from. You say, okay, my company is managed from the holdco, which is in Delaware. Then they will ask you, how do you price transactions between, those entities? And I think for me, the key takeaway here would be that in each jurisdiction, right, or rather, the fact that each jurisdiction they run their own due diligence checklist. So, for example, you have an operating entity in Nigeria, you have your holdco in Delaware. You have to have two separate due diligence checklists for both jurisdictions because they will not be the same, right? At the core, they will be the same, but they will have additional layers to it, right? So the founders who would eventually get this right from day one will get it right from the day of incorporation. They will not get it right at the time of the term sheet, or if they are now, or Okay, let me not say that they will not get it right, or but rather it will be a lot more harder, a lot more expensive to fix if you have to wait till when you have um, a term sheet to review from an investor to now put all of these things in place. It's not impossible, but it will be a lot harder. It might, take a bit more time and it would be expensive, to fix. Next slide, please. Trying to rush through so that we can get to the questions and answer bit. Okay, so this is just you can take a screenshot here. I think the slides will be shared, I don't know, but they should be shared after the conference just so that you can take a look at some of the things, that were said. So just to just briefly glance through it, you can see the investor already took it, what it looks like and what it actually takes to be investor ready. And honestly, if you only remember one slide from today, make it this one, right? And that's why I said you should just take a screenshot, right? You need a clean cap table, your agreement should be signed. So just you should be able to take these things off your checklist, right? Key contracts, corporate housekeeping for your minutes, your resolutions. If you recall, we discussed this at the beginning of the presentation where we spoke about corporate housekeeping, keeping your minutes, board resolutions. Those are all key things that need to be in your investor ready toolkit. They need to be in your data room. And so yeah, those are the things that you absolutely need. Non-negotiables, if you may call them that. Next slide, please. Okay, so build your data room before you need it. Now, this is just like a practical know-how as to how you can actually build, right? And this is you can take this how you want to take it, but this is just from my own experience. Now, 6 months before you plan to raise, run a corporate housekeeping audit. What does that mean? You get your filings, you get your minutes, you get your resolutions, board resolutions in order. 3 months before you do your IP and contract cleanup, chase down every outstanding IP assignment that is filled that you have not, you've not engaged in, you've not considered things you didn't consider as important. You start to put that down, put that together, right? And I would say 6 weeks before you assemble your actual data room, you must get it legally reviewed. You must have a lawyer to take a look at it and spot the issues, because the lawyer is not just going to be looking as your lawyer, they will be looking as someone who's experienced, who is experienced with investors, and so they know what to look out for to ensure that you are properly ready. And then at the term sheet stage, you simply open up that data room for your investors, because it's already been built. So you're looking at a 6 months type of timeline to prepare your data room. Can this be done in a shorter time period? Yeah, definitely. I'm just saying 6 months because if, for example, if you're trying to raise, you're not going to wake up today and then raise tomorrow morning. Although I believe in miracles, so that's actually possible. But yeah, it's just like 6 months, just so you're not under any pressure. In 6 months, you're looking at, okay, you know what, I'm going to build this data room where I don't have this agreement, I've not done my trademark, I don't have my IP assignment agreement, I don't have all of this in place. You can just take that time to build all of this and structure it out and ensure that by the time you get to the term stage points to speak with investors, you are already prepared, you are ready. Yeah, next slide. Okay, so these are just some mistakes I see founders make, and I tend to find this out during due diligence. And it's also some of them are really expensive mistakes. Some of them we've already discussed. Mixing personal and company finances. I know it feels harmless when you are small, but essentially, when you grow to the level that you are now talking to investors, this becomes a very big problem later on, because you have to explain every spend, because auditors will look through your finances. Oh, okay. Auditors will look through your finances, and be able to tell, okay, this is what you did wrong. Why did you spend this amount of money on this, and that? Skip investing. This one is a major issue, and it's always conversation um, point for founders where they skip vesting with their co-founders simply because they trust each other. Yes, trust has nothing to do with co-founder splits. So it doesn't survive a co-founder breakup. And so if at the end of the day, the investor schedule is what will make or mar anyways your business. Number three will be letting a developer to keep the rights, IP rights for now. No, you prepare the agreement from the get-go before any ideas are even shared. Then the fourth will be treating regulatory compliance as a one day, we're not yet ready, we've not reached their problem. No. The fifth one would now be negotiating a term sheet without a lawyer in the room. This is a huge mistake that I've seen founders make, and then they get into trouble. I'm speaking out of experience on this whole subject matter. The next slide, yeah, just okay, so some quick wins you can start with this week. Again, you can just take a screenshot of this, pull your cap table, confirm every signature is on file, confirm your IP assignments, that they exist for every contributor, even including you yourself. Create a folder with your top 10 contracts, check your CSE filings, write your company's regulatory obligations on one page. These are just some quick wins that you can just take a screenshot of and just, you know what, I can start this week, I can start next week, Monday. Yeah. Next slide. Uh, okay, so just as we head into questions, here's just a few things I want you to walk away with. Number one, due diligence, would reward founders who tell the truth on paper and not just out loud. Number two, most red flags are fixable if you catch them before investors do. Number three, cross-border raises multiple paperwork, not just it's not just opportunity, you must see it as added responsibility. Number four, start your data room today, not the week before the term sheet. I think that brings us to should I say my favorite part? Over to you guys. Cap tables, term sheets, war stories, co-founder disagreements, whatever is on your mind. I think this is the point where I get to hear it. You